my dear students, now let me speak on medico-legal aspects of injuries. Section 2, bracket 14 of Bharatiya Nyaya Sanhita defines what is injury. You know very well, if you ask a doctor in a medical field, injury means discontinuity in the continuity of any living tissue. But as per law, injury means any harm whatever illegally caused to any person in body, mind, reputation or property. Say for example, I go and hit a person, that is injury to the body. I abuse a person, it is injury to the mind. I talk dishonestly about a person or I give some statement in the social media or newspaper, anywhere, then it is injury to the reputation. I steal any movable property of a person or even immovable property, I put fence in somebody else's land, that is injury to the property. Now, what is section 114 of Bharatiya Nyaya Sanhita? 114 of Bharatiya Nyaya Sanhita defines what is hurt. Hurt means bodily pain, disease or infirmity caused to any person. And infirmity means weakness. This weakness may be mental weakness or physical weakness. Say for example, if I hit a person, bodily pain, I take a syringe which is having HIV positive blood and inject it to somebody else. I am causing disease into somebody else's body. At the same time, weakness. Say for example, I call a person for dinner. As soon as he comes, I lock him in a room. I don't feed him anything. Then he gets physical weakness. What about mental weakness? Say for example, one student comes to me and he says, "Sir, I don't understand anything in forensic medicine. What to do?" Then I say, even if you read 1 year, 2 years, 10 years, you will never ever pass your forensic medicine. That means I may give him mental weakness. All these come under hurt. Injury is defined under which section of BNS? It is 2 bracket 14. Section 116 of Bharatiya Nyaya Sanhita defines what are all the injuries come under grievous hurt, or what are all the hurt comes under grievous hurt. Here there are 8 clauses. The first clause is emasculation. Emasculation means person loses the power of erection. It may be due to cutting of the penis or castration or causing injury to the spinal cord. Number 2, permanent privation of the sight of either eye. What do you mean by privation? Privation means loss. Remember, the loss should be permanent and it may be partial or complete. Say for example, if a person is suffering from hemianopia, that is also comes under grievous hurt. Number 3, permanent privation of the hearing of either ear. Already I told privation means loss. Again, it should be permanent, but it may be partial or complete. Number 4, privation of any member or joint. Now the question is, what do you mean by member? Member means any part or organ of the body which has got its own function. For example, our fingers, a member of the body. Eye is a member of the body. Liver is a member of the body. Even fingernail is member of the body. What are the functions of the fingernail? If you want to pick any nail or even thorn or even for the scratching, you require nails. So almost everything what we use in our body is member of our body. Number 5, destruction or permanently impairing of the powers of any member or joint. Say for example, I take a scalpel and cut the radial nerve or cut the ulnar nerve. I may get aphthum deformity. That means I am causing permanent impairing of the power of that particular part of the body. Number 6, permanent disfiguration of the head or face. Here the problem is, it is subjective. For undergraduate level or even your PG level or NEET PG examining level, what we say is, any injury which give rise to scar formation amounts to grievous hurt. For example, abrasion over the face does not cause scar. Bruise over the face does not cause the scar. But abrasion of the cornea may give rise to opacity and person may lose his eyesight. That already I discussed under mechanical injury. So in your level, if at all there is any scar, say for example, incised wound over the face or head, lacerated wound, chop wound, all these fall under permanent disfiguration of the head or face. See this picture. This image definitely can say that her face is disfigured. But in this case, it is up to the judge at the end whether he consider whether it is permanent disfiguration of or not. Now, scar on head or face can be disfiguration. Number 7, fracture or dislocation of any bone or tooth. Look here, in medical field, we say dislocation means complete displacement, subluxation means partial displacement. As per law, subluxation also fall under this clause that falls under dislocation. Even strictly speaking, hairline fracture also can be a fracture because they just mentioned fracture. They never said hairline fracture or major fracture, whatever it is. Number 8, any hurt which endangers life. For example, a stabbing into the abdomen. It does not fall under any other 7 clauses, but it endangers the life of the person because it may give rise to peritonitis, septicemia, and death of a person. Or which causes the sufferer during the space of 15 days in severe bodily pain. Say, for example, multiple contusions over the body, where he suffers from minimum period of 15 days from severe pain, it falls under grievous hurt. Or for a period of 15 days, he is unable to follow his ordinary pursuits. Ordinary pursuit means your day-to-day life. Getting up from the bed, brushing the teeth, or dressing, undressing, or going to your workplace or to the college. So here, 8 clause has got 3 subclauses. Okay. And here you remember, unable to follow his ordinary pursuit means he should be almost bedridden. Remember, if a person gets admission to the hospital for 15 days or more, it is not grievous hurt. Understood? In 15 days, he should be under severe bodily pain or unable to follow his ordinary pursuits. Mere hospitalization is not grievous hurt. Just because the person gets admitted in the hospital where he is almost all right, then it is not grievous hurt. Now, all these 8 clauses together in a single frame. Okay. Section 116 deals with grievous hurt. Subsequently arrange the clauses of section 116 BNS. Of course, that time they ask about the 320 IPC. Now I just changed. You know very well all these 8. The answer is 3, 1, 2, 4. Which of the following constitute grievous hurt? Incised wound of thigh? No. Incised wound of scalp? Yeah, it gives rise to permanent disfiguration because of scar formation. Laceration of the forearm? No. Black eye? Black eye means just bruise of the eye. Okay. So answer is incised wound of scalp. Grievous hurt include all the following except privation of any member or joint is a grievous hurt. Disability to follow one's ordinary pursuit for a period of a week. Wrong. It should be 15 days. Emasculation, permanent privation of hearing, both are grievous hurt. Which of the following constitute grievous hurt? PGI. Incised wound of thigh? No. Incised wound of scalp? Yes. Laceration of the scalp? Yes. Fracture of tibia? Yes. Because it gives rise to scar formation. Any hurt is grievous provided the victim is unable to follow his ordinary pursuit for a minimum period of 15 days. Previously it was 20 days, now it is 15 days. Which of the following constitute grievous hurt? Incised wound of thigh? No. Laceration wound of the forearm? No. Hospitalization for 21 days. I just told mere hospitalization does not amount to grievous hurt. Now the answer is complete avulsion of nail, because already I told nail is the member of a body. once it is completely avulsed, you are losing your nail. Say, for example, important function of the nail in our day-to-day life is scratching. If you don't have nails, we have to be like a cow. If at all we get some itching, you have to go against a rough wall or rough surface and you have to scrape our body. So best answer here is complete avulsion of nail. Which of the following constitute grievous hurt? Incised wound of thigh, partial avulsion of nail, corneal abrasion, hospitalization. Answer is corneal abrasion because it may give rise to opacity and loss of eyesight. Which of the following injuries is grievous hurt? Abrasion over right side of face, abrasion of right cornea, subconjunctival hemorrhage, breaking of fingernail. So answer is abrasion of right cornea. A teacher slapped a student after which suffering from 25% hearing loss. This was corrected after a surgery. What kind of injury is this? Many students say that it is not a grievous hurt because it has been corrected. But remember, medical or surgical intervention is irrelevant. Nature of injury is irrespective of medical intervention. So this injury is grievous. All the following injuries are also considered to be grievous hurt under section 116 BNS except here the answer is admission in a hospital for 7 days. Emasculation, fracture of femur, permanent privation of hearing, all are grievous. Grievous hurt is said to be there if the person is in severe bodily pain or unable to follow ordinary pursuit for a minimum of how many days? Now the answer is 15. Before it was 20. Okay. Now, what do you mean by medico-legal nature of injury? Tomorrow, a judge may ask me, doctor, that injury, what is the medico-legal nature of that injury? Now, I can give 1 out of 3 answer. Number 1, necessarily fatal. Number 2, sufficient in ordinary course of nature to cause death. Number 3, likely to cause death. How to differentiate? Necessarily fatal in the sense there is no chance of survival at all. Person has to die. He must die. For example, gunshot injury to the head or decapitation or a lorry tire passing over the head. He has to die. Number 2, sufficient in ordinary course of nature to cause death in the sense, say for example, I give an example. I am a surgeon. A patient comes to me with the history of stabbing into the abdomen where intestine has protruded. He comes to me by holding his intestine in his hand. Then I say it needs emergency operation. It cost about rupees 50,000. But he says, doctor, I am having only 500 rupees. Do something. I say, no, impossible. Immediately, please go to at least a government hospital and get operated. After 1 month, he comes to my hospital, start abusing me that I am very much money oriented. Other day, I wanted to do unnecessary operation on his body. Then I ask, what happened? Have you not underwent surgery? Then he says, no, nothing. I went to a medical shop. I purchased a band-aid for 2 rupees. I pushed all my intestine into the abdominal cavity and I applied a rubber band. Sorry, not rubber band. This band-aid. Now you see, perfectly all right. Now, survival is surprising. Survival is surprising. Otherwise, in ordinary course, we expect that person to suffer from peritonitis, septicemia and death. But here, he survived. What do you mean by likely to cause death? I meet a student after a long time, maybe after 25 years. He was my student 25 years back. That time he was very lean. Now he comes to me, sir, how are you, sir? I'm sorry. May I know who are you? Sir, you don't know. I'm Mr. Krishna Kumar, your student in 1995. Then I think, yeah, I remember Krishna Kumar was very lean. Now he has become so fat, about 140 kg. Then immediately I hit on his upper abdomen. Hey, what is your belly? Immediately he dies. Death is surprising. He must have died of vagal stimulation by me hitting on his epigastric area where it has stimulated the pampiniform plexus. That is the medico-legal nature of injury. Look here. The medical nature of 40% body surface area burn is As per our present law, what they say is originally, if the body surface area burnt is more than 1/3 of the total body surface area, it is sufficient in ordinary course of nature to cause death. So 40% body surface area is sufficient in ordinary course of nature to cause death. Now, I will talk about some important sections which come under injuries, Bharatiya Nyaya Sanhita 2023 or BNS. Section 100. Definition of culpable homicide. Culpable means punishable. Okay, culpable means punishable. 101 of BNS. Definition of murder. What is murder? It also defines what is culpable homicide not amounting to murder. I will explain later. Section 103. Punishment for murder. Punishment for murder. 105 BNS. Punishment for culpable homicide not amounting to murder. Section 109. Attempt to murder. 110. Attempt to commit culpable homicide. 118. Voluntarily causing hurt or grievous hurt by dangerous weapon. Voluntarily causing hurt or grievous hurt by dangerous weapons. Now, whenever law says attempt to commit culpable homicide, once they just say culpable homicide, that means it is not amounting to murder. Once you say murder, that means culpable homicide amounting to murder. You understood? Again, I repeat. Once we say culpable, only culpable homicide, that means not amounting to murder. Once you say murder, that means it is culpable homicide amounting to murder. Now, what is homicide? You know, our species is Homo sapiens. Side means killing. Killing of one Homo sapien by the act of other Homo sapien is known as homicide. It may be directly or indirectly. Say for example, tomorrow, I am having a ferocious dog. I tell the dog, attack. And if the dog attacks and kills another person, it is homicide only because I only caused his death. And this homicide may be justifiable homicide, culpable homicide, and excusable homicide. I told you clearly, culpable means punishable. That means justifiable homicide and excusable homicide are not punishable. Now, coming to the justifiable homicide. Justifiable homicide means killing of a person is justified by the law. Justified by the law. How it is justified? For example, military war or judicial execution. Judicial execution. The court has passed a sentence of death. It will be executed by a person. It is justifiable homicide. Or military war. You are authorized to kill soldiers of enemy country. The more and more soldiers you kill of enemy country, you will get more and more award. What about excusable homicide? Here, killing is excused by the law. How? Beautiful example is accidental death during sports or games. Accidental death during sports or games. Say for example, Jayaprakash Bumrah bowls a fast ball and it hits the head of a batter who never wore helmet and he dies of head injury. Bumrah will not be punished. Okay, look here. Phil Hughes, Australian cricketer, died because of ball hitting his head. Umpire gets hit by ball on head, dies a month after being in coma. Not punishable. Now, what is culpable homicide? Culpable homicide are of two types. Number one, amounting to murder. Number two, not amounting to murder. As I told earlier, if you say murder, that means culpable homicide amounting to murder. If you just say culpable homicide, it is culpable homicide not amounting to murder. Now, let me explain how to differentiate between culpable homicide amounting to murder and not amounting to murder. And you have to remember one more thing. Whenever you use the word homicide, that means person is dead. Whenever you say murder, that means person is dead. If it does not die, it is attempt. Now, I get one intention to kill another person. Number one, I get intention. Intention is there. Then, I inflict one serious injury on his body. The gravity of injury is severe. That means the act is such as to cause death. Say, for example, I take a gun, shoot a person on his right temple. All of you know, this injury is almost necessarily fatal, or at least sufficient in ordinary course of nature to cause death. Person dies. Now, I am punishable for murder under section 103 of BNS. It is murder. Okay. Meantime, I get an intention to kill. Then I cause or inflict an injury on the victim. Gravity of injury is severe, but it does not die. It does not die. Then I am punishable under attempt to murder. Okay. For example, I take my gun, shoot at a person, the projectile enters into the abdomen. Immediately will be taken to the hospital, surgeons repair, and he survives. Now, I am punishable for attempt to murder under section 109 of Bharatiya Nyaya Sanhita. You understood? Now, again I have an intention to kill. I inflict one injury on my victim. Gravity of injury is not severe. That means the injury what I caused is not sufficient in ordinary course of nature to cause death. It usually won't cause death. But unfortunately for him, he dies. For example, I shoot a person on his palm. Then it comes out on the other side, a perforating gunshot injury. Ordinary circumstances, this injury is not sufficient to kill a person, but unfortunately, he is diabetic, he suffers from septicemia, and at last he dies of septicemia. Now, I am punishable under section 105 of Bharatiya Nyaya Sanhita for culpable homicide not amounting to murder. It is not amounting to murder because this injury is not sufficient in ordinary course of nature to cause death. Meantime, same person, same injury, he does not die. I have an intention to kill. Gravity of injury is not severe. Death does not take place. Now I am punishable under section 110 of BNS for attempt to culpable homicide not amounting to murder. That's what. So here most important is, number one, there should be intention. Number two, what is the gravity of the injury? Number three, whether it dies or not. Okay. See, this explanation is only for your MCQ purpose. If you go and if I teach a law student, this is not sufficient because many times person can be arrested even without any injury on the body. For example, I take my gun and shoot at a person with an intention to kill. The bullet just passes next to his head. There is no injury. I can be arrested for attempt to murder. Understood? But it is only for your MCQ purpose. Now, look here. Again, I am showing you basic BNS, what you should know. Okay. Now, X shoots Y with an intention to kill. There is intention. Once there is intention, it may be culpable homicide amounting to murder or not amounting to murder. Causing wound on the thigh, the bleeding in the thigh stops spontaneously after some time. That means gravity of injury is not severe. So, he can rule out murder. Under which section of BNS X can be punished? Now here, person is survived. So it is only an attempt. Only an attempt. If it dies, then only murder or culpable homicide not amounting to murder. But here he has survived. So here person has intention to kill. The victim survived. So is punishable under section 110 of BNS. Attempt to commit culpable homicide not amounting to murder. Not amounting to murder means severity is less. Attempt because he is not died. Now, 103 punishment for murder. 105 punishment for culpable homicide not amounting to murder. Okay. Now here it cannot be 105 because he did not die. It is not murder because he did not die. Now 118 is voluntarily causing hurt or grievous hurt by dangerous weapon. Of course, it is causing hurt, but here intention is there. If intention is not given, then your answer can be 118. X fired his gun at Y, who moved and escaped the bullet, only grazing his thigh with only little bleeding, under which section of BNS X can be punished. Now here, intention is not mentioned. So, we can come out from culpable homicide. Okay. At the same time, you look here, injury is a minor injury. It is not even grievous hurt. So now, he is punishable under section 118 of BNS, voluntarily causing hurt by dangerous weapon. Voluntarily causing hurt by dangerous weapon. Previously, 324 IPC, voluntarily causing hurt by dangerous weapon. 326 IPC, voluntarily causing grievous hurt by dangerous weapon. But now, they have included both together under 118 under subclause 1 and 2. You can forget about that. Okay. Now 103 punishment for murder, 105 punishment for culpable homicide not amounting to murder, 110 attempt to commit culpable homicide not amounting to murder. Now coming to the dangerous weapon. Dangerous weapon is defined under section 118 of Bharatiya Nyaya Sanhita. Dangerous weapon is any instrument used for cutting, shooting or stabbing. Any sharp instrument, any firearm, any pointed weapon, or any weapon or any instrument when it is used as weapon of offense is likely to cause death. When it is used as weapon of offense, likely to cause death. Strictly speaking, according to me, each and everything available on the earth is dangerous weapon. For example, hammer, dangerous weapon, punch, dangerous weapon, handkerchief, dangerous weapon. You can use for gagging, you can use for smothering, even you can use for strangulation. Even rice particle is a dangerous weapon. You can introduce 1 or 2 rice particle into the nostril, especially of a baby. Person may die of laryngeal spasm. Even water is a dangerous weapon. Everything is dangerous weapon. Okay. Now, dangerous weapons are related to which BNS section? Answer is 118. What do you mean by dangerous injury? Any injury which poses immediate danger to life. Any injury which poses immediate danger to life. In other words, clause 8 of grievous hurt. That is, any hurt which endangers the life falls under dangerous injury. For example, stab injury to the chest, stab injury to the abdomen, stab injury to the cranium, or extradural hemorrhage more than 100 ml. All these are dangerous injuries. Now, what amongst the following is a dangerous injury? Corneal abrasion is a grievous hurt but not a dangerous injury. Rupture of tympanic membrane is a grievous hurt but not a dangerous injury. Fracture of radius, it is not a major bone like a femur. It does not pose immediate danger to life, but extradural hemorrhage more than 100 ml, definitely dangerous injury. One of the following is not dangerous injury. Stab injury to the eye, penetrating injury to the chest, definitely dangerous. Penetrating injury to abdomen, dangerous. Penetrating injury to cranium, dangerous. But stab injury is definitely grievous hurt, but it does not pose immediate danger to life. Now, which among the following can be categorized as dangerous injury? Injury causes endangering to life. Yes. Synonymous with grievous injury. Wrong. Emasculation. No. Fracture of femur. There are chances of hemorrhagic shock or fat embolism. Loss of 2-3 teeth? No. I hope you have become expert in knowing dangerous injury, dangerous weapon, homicide, murder, all these things, hurt, grievous hurt, everything. A fully conscious person reported to the ER of a tertiary care hospital with an alleged history of injury to the head during a fight. On clinical examination, there was a boggy swelling of 6 into 4 centimeter on right parietal area. X-ray revealed undisplaced fracture of right parietal bone. What kind of injury is this? It is definitely grievous hurt because there is fracture. But it is not a dangerous injury because it does not pose immediate danger to the life. So answer is grievous. An area of negative vital reaction is seen in antemortem wound, postmortem wound, perimortem wound, or both antemortem and postmortem wound. What do you mean by negative vital reaction, positive vital reaction, and no vital reaction? Look here. In case of any injury over the body, there will be a central zone and peripheral zone. Central zone is immediate next to the wound, about 0.2 to 0.5 millimeter, very small area, where there will be decreased enzymatic activity. That is known as negative vital reaction. Okay. Whereas, just next to the central zone, there is peripheral zone, 0.1 to 0.3 millimeter, where there is increased enzymatic activity, that is known as positive vital reaction. So, negative vital reaction and positive vital reaction is seen only in antemortem wounds, not in postmortem wounds. In postmortem wounds, there will be no vital reaction. So, here answer is antemortem. Again, I repeat, in antemortem wound, there will be decreased enzyme activity known as negative vital reaction, increased enzyme activity known as positive vital reaction. Okay. Now, one of the following is the first enzyme or biochemical markers to be released at the site of wound. No need to remember each and everything, but I give you a list. After sustaining injury, there will be release of enzymes or some biochemical markers. The first enzyme or biochemical marker to be released is tissue cathepsin in about 5 to 10 minutes. Okay, just remember about tissue cathepsin 5 to 10 minutes. And also remember esterases and ATPases, that is the enzyme which will be released within 1 hour. So here, just remember, first enzyme or biochemical marker to be released is tissue cathepsin within 5 to 10 minutes, whereas esterases and ATPases within 1 hour. Now, what do you mean by Havning postulates? Havning postulates concerned with which of the following? It concerned with the relationship between the trauma and tumor. Trauma and tumor. Sometimes person may sustain a trauma, any type of trauma, then there will be scar formation. A scar may get converted into malignant tumor. That is Having's postulates. A 60-year-old girl comes to a doctor with the fractured forearm. She told she tripped and fell. But cigarette burns were observed on the forearm. What will be your next step? To inform higher authorities? No. Your authority itself is sufficient. To do a complete physical examination, of course, you have to do a complete physical examination. As a doctor, first you have to do, after taking history, you have to go for a complete physical examination. To tell or discuss with colleagues that she is a case of abuse, why you want unnecessary talk? To call local social help worker for help, why? She has come for treatment, you just treat her. Later, if you want, whether there is any abuse or anything, then you can inform the proper authorities or inform police. Okay. Homicide case comes to a doctor, he must inform the police. This comes under BNSS. Answer is 33. What is 33 BNSS? Previously it was 39 CRPC, now it is 33 BNSS. BNSS, Bharatiya Nyaya Sanhita. According to that, it deals with duty to give information to police. Duty to give information to police. As a doctor, forget about other things. As a doctor, Any homicidal poisoning or homicidal case, all this comes to us, we have to inform the police. At the same time, if death takes place by anesthetic complication or surgical complication or whatever it is, if the person dies on operation table or maybe post-operative also, it is your duty to inform police. That is 33 BNSS. That is regarding medico-legal aspects of injury. Okay? Bye-bye.